my learned friends. It is a very important event and occasion today when we have a foremost jurist from our neighboring India make a special visit. For this address alone, Mr. Diwan arrived at 11 p.m. last night and he leaves at 5 p.m. today. And the purpose, the singular purpose of his visit to Sri Lanka is to address all of us, all of you, and our membership who are joining virtually on the important topic of deepening democracy, constitutions, and constitutionalism. Mr. Diwan is the fourth foreign jurist who have shared their views with us in the last week. Last Saturday, we had Mr. Stephen Thiru, former president of the Malaysian Bar, and the present president of the Commonwealth Law Association, speak to us on constitutions, the dangers of ad hoc constitutional amendment, and of course, the wider concept of the rule of law. We also had the president of Law Asia, a senior member from Singapore, Mr. T. Lap, echo those same sentiments, of course, from a different perspective. Then 3 days ago, we had the president-elect of the New Zealand Bar, Dr. Simon Foote, King's Counsel, speak to us at this H.W. Jayawardena QC auditorium on his understanding of the rule of law and where constitutional governance, constitutionalism, and of course, prospective amendment places itself. And something we saw in the commonality of those three addresses was that there are many dangers that we now face. We might call it constitutional turbulence in this most beautiful island in the world. So I'm extremely appreciative and thankful to Mr. Diwan for agreeing to come down and to share with us. We don't know what your view is so far, but we are open to discussion and agreeing to come down and share with us your thoughts and your reflections on what deepening democracy means in the realm of constitutions and constitutionalism. The Bar Association of Sri Lanka, as I mentioned to our young members earlier in the morning, acts on principle, not on favoritism, not on friends and connections, but purely on principle, and certainly not to do with politics. Sometimes, as I spoke to you also, principled decisions are not popular decisions. Principled decisions sometimes are difficult decisions. But as lawyers, as legal professionals, we need to act in accordance with our conscience on our understanding as what is right over what is wrong. It is certainly not about personalities. It is about the interest, the well-being of our nation and our citizenry. And this is not the first time we have come out in objection to various proposals and decisions of a particular government in power. Governments come and go. Leaders come and go. Personalities come and go. But the principles, the Constitution, and the interest of the state, of the nation, does not change like that. It was a decade ago that the Bar Association stood firmly against the most unlawful removal of the then Chief Justice, Her Ladyship Justice Shirani Bandaranayake. All of that opposition commenced from this hall and from the Bar Association. We are presently confronted with a very similar issue, probably the converse of what happened then. And that is why, without fear or favor, without anything collateral, we are sticking by our principle. And we will say what we have to say, as much as we can, as loud as we can. And I'm hopeful that the decision makers would take due and proper cognizance of the legal profession when we stand in one voice saying, this is not something that you must do at this juncture. It is against all principles we have learned and we have heard of. Please don't do this now. Let us get into a wider discourse and look at whether this is necessary at some future point of time. But certainly, the imperatives are different. Our justice sector, which presently has probably 0.5% of state expenditure, has to go up. We need to have more investment. We need to have more courts, appointment of more judges, use of more technology, and so on. The problem is somewhere else. So let us see through the mist, so to speak, and let us understand the issue. And certainly, collectively, all of us, the state government, the Bar Association, the legal profession, the judges, let us together resolve the issue, but not get into ad hoc, knee-jerk changes, which is, in our humble and respectful view, not suitable at this point of time. So thank you, Mr. Diwan, and I must also, as tradition requires, to introduce you to our esteemed learned audience. And I must tell you, reading your profile, I'm extremely impressed by what you have done over the years. I will not go into all the details. It will take a lot of time. Mr. Shyam Diwan, the senior advocate and practices before the Supreme Court of India. His areas of practice cover constitutional law and most branches of civil litigation, including banking, securities law, arbitration, administrative law, and environmental law. He appeared in several constitutional cases decided by the Supreme Court of India, including the cases of Abhiram Singh, which dealt with election law, the case of Justice K.S. Puttaswamy versus Union of India, which was to do with declaring privacy as a fundamental right. That was in 2017. The case of Navtej Singh Johar versus Union of India, to do with decriminalizing homosexuality. Then again, another case, Justice K.S. Puttaswamy, challenging the biometric program called ADA in 2019. Indo Development Authority versus Manho Lal, which has to do with the parameters for recusal by a Supreme Court judge. The case of Kantaru Rajivaru was to do with contours for religious freedom. The case of Vivek Narayan to do with demonetization of the currency, which we remember took place in India. The Animal Welfare Board case to do with the challenge to the practice of Jallikattu involving cruelty to animals. Case to do with Section 6A of the Citizenship Act, and a numerous number of similar cases. And when I said an esteemed jurist, I think I underestimated Mr. Diwan. He has covered the entire cross-section and breadth of constitutional law and administrative law in these landmark cases. Mr. Diwan assists the Supreme Court as amicus curiae in several cases, including the Bellary case involving illegal iron ore mining in the forests of Karnataka, and a case where the Supreme Court is considering the issue of legal responsibility of lawyers for contents of AI-generated work used in court. He also appears for the states of Haryana and Karnataka in interstate river water disputes. He is a co-author of the book Environmental Law and Policy in India, Cases and Materials, which is an Oxford publication, and has authored chapters on public interest litigation in the Oxford Handbook of the Indian Constitution, that is 2016, and the Environment and the Constitution in the Oxford Handbook of Environmental Law again in 2024. His chapter on the M.K. Ranjit case will appear in the Turning the Tide, a Decade of Climate Change Litigation, which is a publication which is forthcoming this year. In 2021, Mr. Diwan received the International Privacy Champion Award for the Electronic Privacy Information Center from the Electronic Privacy Information Center for his role in a state of privacy protection cases. Mr. Diwan served as President Law Asia between November 2023 and October 2025. He is the Vice President of the Bar Association of India, and Mr. Diwan also serves on the governing boards of the Center for Policy Research, New Delhi, and the Independent and Public-Spirited Media Foundation in Bengaluru. Mr. Diwan, we now look forward to what you have to say. We don't know what you're going to say. What you have to say about all of this that we are presently challenged with. Over to you.